This hearing is in the matter of case number CFI 056-2021 before Justice Sir Jeremy Cooke. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Mohammed Al-Injawi, advocates and legal consultants. Lead counsel is Mr. Khadr Ibrahim Khadr. The defendant is represented by Holman Fenwick, William Middle East LLP. Lead counsel is Mr. Stephen Dahatri.
Very good. Thank you very much. I'm sorry about the problems over the sound, but I hope you can all hear me and I can now hear you. It's your application, Mr. Doherty, so do you want to begin?
Yes, Your Honour. I hope you can hear me clearly enough, but if at any point it breaks up, obviously, please just let me know. As you'll have gathered from the papers, this is the defendant's set-aside application. It's a slightly unusual case, only insofar as Your Honour may have seen. My client has never denied that the claimant has got some entitlement to certain post-termination benefits. The issue in this case is really on what legal basis and what the amount of his entitlements are. Because of that, it sent the claimant a letter on the 23rd of September of this year, setting out what those entitlements were in the sum of around $207,000 and asking for details of the bank account that sum could be paid into. I won't take you to it at the moment, but for your note, that's it. Tab E of the bundle, page 15. And I understand that I've read.
You can take it that I've read the witness statements and the key exhibits, including that letter.
Yes, fantastic. Thank you, Your Honour. Much appreciated. And I understand that the claimant still hasn't replied to that. And to the extent he now says that his contractual dues are being withheld from him, it's our position that all he needs to do is respond to that letter and provide his bank account details. The purpose of this application is that we say that 23rd of September letter sets out the full extent of the claimant's legal and contractual entitlements. And despite that, the claimant resists this application in the hopes of executing judgment for somewhat over twice that amount. That's a little over $447,000. So the application is made primarily on the basis that the defendant has a real prospect of defending the claim. And in fact, we go so far as to say that it's the claimant that has negligible prospects of success. Your Honour will also have noted that we say judgment can also be set aside due to what can either be classed as issues surrounding defective service of the claim form, or at least some material uncertainty regarding proper service. But putting that to one side, that, together with the injustice that my client would suffer if it wasn't permitted to defend the claim, we say is a sufficiently good reason to set aside judgment, even putting aside the test on real prospects. So that's a brief introduction. What I intend to take you to, Your Honour, and feel free to accelerate me through any of this if you've seen it, but I'll go first of all to an outline of some of the factual background. Second, I'll go to my submissions on real prospect of defending the claim, and then finally, I'll address you on the good reasons why we say judgment should be set aside.
Well, I'm pretty familiar with the background. There's a question I want to ask you at the outset. It's this. Leaving aside the question of any irregularity in service, and therefore whether the judgment should be set aside ex judicia, whatever the expression is, you would accept, would you, that otherwise judgment would only be set aside for the disputed sum over and above the 207,000 that you accept is due in the 23rd of September letter?
No, I don't think that position is quite correct. There are a few reasons I say that. The first is the manner in which the case has been put and the manner in which it's been pleaded, which Your Honour will have seen I referred to in my skeleton argument. To put it in relatively brief terms, we say there isn't a coherent claim there. The claim form, if Your Honour has seen it, sets out, I think, about one line describing the claim. It's at A1, if you want to look at it.
Yeah, I've got it.
And all it says is end of service gratuity, unpaid salaries, notice period, aggressive termination, annual leave, travelling tickets. And our position is that we don't accept that that properly puts what the claimant's entitlements are. And I've set out in my skeleton, and I'll come on to in due course, the reasons why we say those issues are either not properly put, or at the very least, there's a triable issue. In particular, Your Honour will note the claim for aggressive termination is one which we say has no legal or contractual basis. We dispute.
I follow all of that. I follow all of that, Mr. Doherty. But the position is that on the 23rd of September, you accepted that some $207,000 US dollars was due. And the theory is that that should have been paid within 7 days of the end of the employment of the claimant, isn't it? That's what the law requires. And you should have furnished such a statement and made that payment at that stage. I mean, this is why it seems to me some questions may arise in relation to the irregularity of service and so on and so forth, because if you're entitled to have it set aside on that basis, then judgment is set aside in full. But if it solely depended on the merits of the case, I can tell you now, subject to anything Mr. Khadir wants to say, and obviously I must give him a full opportunity to have his say, but on the face of it, it looks like you've got a real prospect of success for everything over the top of the 207,000. But if there were no questions of irregularity of service, I would be thinking that judgment ought to be maintained for the 207,000. Costs, of course, is another question, and that can be dealt with separately.
Yes, Your Honour, I take your point on that. I think what we would say is that given the situation in which there isn't a dispute over that sum, there is still certain prejudice, first of all, in having judgment entered in the first place where the amount is not disputed and ought not to be an issue before the court at all. There is also an issue, and I'd be happy to find the judgment, but in relation to partial setting aside of a judgment, where there are residual issues to be tried, which we say there are here. So, for example, when it comes to, again, the claim here as pleaded, and we say this would raise questions about what judgment is being entered over and which issues it's being entered in respect of. But when it comes to notice period, there is at the very least, we say, triable issue, because that's going to involve investigation of the circumstances surrounding termination.
Mr. Doherty, you misunderstand me, I think. Until I've heard from Mr. Khadir, which I haven't yet, it appears to me that you have, as I say, a real prospect of successfully defending the claim in everything over and above the 207,000, and all the question of notice period and termination for cause and so on raises clear factual disputes that can't be resolved on an application of this kind and would have to go to trial. But so far as the 207,000 is concerned, you accept that's due. Now, I know there may be questions of cost that arise because of how the judgment's been entered and all the rest of it. I know there may be questions of irregularity of service, which would entitle you to have the whole of the judgment set aside. But on the face of it, you accept you're liable for 207,000, and that ought to have been paid, and could no doubt have been paid, because you had bank accounts of which you had knowledge, from which you were paying, into which you were paying salary at the time. So it could all have been done within the 7 days that the contract requires.
Yes, Your Honour, you've seen the evidence. The issue I was raising with Your Honour was the issues of entering partial judgment anyway. As I say, because of the way it's pleaded, it's not entirely clear what if any issues, that money judgment would be entered over. And there's the case of it's Al-Tamimi and Joram. The reference is 2016 DIFC CFI 028. It's the 16th of July 2017 judgment.
I can't say I'm familiar with it.
Yes, well, perhaps I can summarize, and I can try and get hold of the judgment because it's not in the hearing bundle. But the point really in that case is expressing caution over entering partial judgment, particularly where the judge in that case found that it can serve to tie the hands of the eventual trial judge where there are residual issues to be tried.
Yeah.
And in that case, it was found that it would be inappropriate where there was a trial to then establish certain other aspects of the case. So I think my point that we would raise, cautioning against the approach that Your Honour is suggesting, is that there are going to be matters in this which are to be deferred until trial. In circumstances where we have a claim form which is said to include the particulars of claim, which has not articulated, we say, in any clear way what the premise of seeking judgment of any sum is, that it would be potentially constraining on an eventual trial judge as and when this claim goes on to be properly pleaded and properly addresses what the residual issues in dispute are, to siphon off what has already had judgment entered over it and what is a residual issue. And so that's why we would caution against that approach. As I say, in practical terms, if the claimant wants his contractual dues, all he has to do is provide his bank account details, and that can be easily settled outside of the court's process. If and when the claim is pleaded properly, if there is any residual issue over which there can't be a dispute, then of course it's open to the claimant to apply for summary judgment in respect of that sum. Again, practically speaking, one anticipates that that's not going to arise. But what we say is that it's not so easy to sever off the money judgment from what the basis of the money judgment is. So one would need to know is what is the 207,000 comprised of? And that, we say, is absent here because we haven't got a properly pleaded case.
All right. Well, I hear what you say. I don't find it very persuasive because you know what you say you should be paying. I'll ask Mr. Hidir now. Is there any reason why you can't give a bank account number so that this money can be paid?
Yes, Mr. Justice. Actually, he didn't reply to, my client didn't reply to the letter dated 23rd of September because this letter come after the judgment and before they deny that there is contradiction. There is a statement of account in which they said
I know that.
And
I understand that. I understand that entirely, Mr. Hidir. What I'm asking you simply is whether you can give a bank account details. If necessary, it can be your own firm's bank account details, and the money can be paid straight away, can't it?
Because they know there
save a lot of time and trouble.
He's an employee with them for 10 years. They know his account and they know his, and the amount which they offer to him, this is not his claim. This is less 50%.
I understand that. I understand that. But
yeah.
Something is better than nothing, Mr. Hidir, from his point of view. It's much better that he should get paid something, and then we can argue about the rest. But because what you're telling the court is that it's the sum that is admitted to be due can be paid into the bank account into which his salary was previously paid. Is that what you're telling me?
You are right, but actually, because his case is still pending before the court, that is why he don't want to make partially payment. He wants to get his claim fully paid to him through the court.
Okay, well, I understand that.
Actually, your Justice, if you can allow me, there are two issues regarding the issue of termination. This letter of 23 September proves that the defendant failed to pay the salaries of the claimant 3 months is before the termination, January, February, March. This itself is aggressive termination. That is why they create a problem that he has been terminated for cause, and they make investigation with another concerning another person, this, and make it in another jurisdiction in Sudan. If there is any investigation, it should be done here within the jurisdiction that the claimant is working, DIFC. Also, there is no accusation addressed to him during the investigation concerning the ex-chairman of the company. And the money which had been withdrawn, the issue of this investigation, withdrawn by the ex-chairman of the company, and all the managers know it. This is since 2015, maybe 6 years before the problem, 6 years before the termination. And that amount is already known in the record of the company and in the books of the company. That is why his termination is not for cause. His termination is aggressive termination because the defendant failed to pay his salaries for 3 months, January, February, March. That is why he refused to reply to them, and their letter dated 23 September. This is proof that they failed to pay his salaries before the termination. And this is the issue which you are insist that your Honorable Justice to the court to take it in consideration. Regarding the, yes, if you can allow me, regarding the service, already after I have been appointed by the client, I contact the manager of the company on telephone. I ask him, there is a case against your company. We need to deal with you with email. Is it acceptable? He said yes. He sent me 2 emails, two numbers of emails. And he asked me to deal with this. The next day, he sent me a 3rd one. He said, okay, this also can be included. At that time, we sent him the claim with attachment, and we make a certificate of service on the portal of the court. This all is done. And they have been given 14 days. They failed to reply. I think in their application, they said they don't know the procedure. This is not correct because there is a lot of cases filed against the company, and they know the procedure before the DIFC courts. That is why I think their application should be rejected because they have already given a chance to reply to the case and they failed. Moreover, yes, the termination is aggressive, not for cause. Even for cause, he asked them within 1 month from the termination. He asked to give the reason of termination. They failed to give him, according to Article 57 of the Employment Law. They failed to give him the reason of termination, and the investigation done with him in another jurisdiction. Also, I think they bring certificates saying that there is criminal proceeding in Sudan. This is irrelevant because he's not working in Sudan, and he has not been given any call or any summons from the public prosecutor in Sudan. That is why we think this application, your Honorable Justice, should be rejected. Thank you.
Yes, well, thank you very much, Mr. Kiria. I'm going to hear from Mr. Doherty, and then I'll ask you to respond in relation to those things I need you to respond on. Mr. Doherty, I don't need you to address me in relation to the arguability of the defences for anything above the admitted sum. In practice, therefore, the areas I want you to address me on are the irregularity points or the doubt about the irregularity points and whether that would entitle you as a matter of law to have the judgment set aside or as a matter of discretion to have it set aside.
Yes, Your Honour, thank you. Well, if you have my skeleton, you'll see that I build through the relevant framework of the rules from paragraph 37 onwards. Yes. And of course, the starting point is questions surrounding service. So as Your Honour will know, the usual position regarding service of the claim form is that it needs to be served to the registered address where we have a company, as we do in this case, there is, in accordance with the rules, provision that one can serve by means of electronic communication. But in order for that to be permissible, the party is to be served or their legal representative has to have expressly indicated in writing to the party service that they are willing to accept service by electronic means. And I would emphasize that language that's in Rule 9.31a, that it is willing to accept service by electronic means. And the point there is that it's not simply sufficient to say, I am willing for you to communicate with me by email. The rules require acceptance of service by electronic means. And that's an important distinction. And if one goes down to Rule 9.33, what we also have is a provision in the rules putting the onus on the serving party to have sought clarifications as to the precise scope of what would and would not be accepted. So what 3 says is that the party seeking to serve the document should first seek to clarify with the party who is to be served whether there are any limitations to the recipient's agreement to accept service by such means. And that includes the format in which the documents are sent, maximum size of attachments. But of course, that's not exclusive. The point is that if a party intends to serve in an irregular way, it should have express consent and it should be clear about what it's proposing to serve. That, of course, then brings us on to what the requirements are for making a request for judgment in the first place. And in this instance, it's Rule 13.4 that applies because the request for judgment was entered because there was no acknowledgement of service. And that requires, first of all, that the defendant hasn't filed the acknowledgement of service and that the relevant time for doing so has expired. Now, the point there is that, of course, for time to start running, in order to require the filing of an acknowledgement of service in the first place, one requires that service of a claim form has been properly effected in accordance with Part 9. And you'll note that I've raised in paragraph 42 of my skeleton argument as well. It doesn't suffice as an answer from the claimant's perspective to simply say that, well, the claim form was sent by email, but ultimately it was received by the defendant, and therefore they had the opportunity to respond to it. But that doesn't indicate that proper service has been effected, nor does the fact that there's an acknowledgement of service. And you'll see I refer at paragraph 42 to the Grand Valley General Trading and TGICO Suntech case.
Yeah.
And the extract of His Excellency Justice Shamlan's judgment.
Yes, well, this is all trite law, Mr. Doherty.
Yes, and you will also notice that the Grand Valley case we also cite as an authority for the proposition that even where there is a degree of uncertainty as to some of those issues surrounding service, that also feeds into the exercise of the court's discretion at Rule 14.2.2. The point there being that if one cannot make a definitive determination as to whether service has been effected or not, that would nevertheless give the court a good reason to set aside. Of course, it can be amongst other reasons.
Yeah.
Now, what we say here, and I'll take your honour to the documents, is that service has not been properly effected. And if we go first of all to tab D of the bundle and page 25.
Yes.
This is where we'll find the chain of communications around this issue. So we have Mr. Kadir's email of the 9th of August. And what he's asking for is confirmation in writing the preferred communication method. and he refers to serving summons. I have to say it's not entirely clear what that refers to, but what it doesn't say is service of the claim form and further communication with the company, email or courier or other. And if we scroll up at the bottom of page D24, we find Mr. Abdel Malik's response to that. Thank you for your email. And he says, please address all the related communications for the time being to the following email addresses. Now, as I've just taken your honour to, what we say is that, first of all, there's no reference in any of the prior chain to service or to service of the claim form. It's in fact much broader than that. It's how would you like to be communicated with? What we say is that the rules require, where there is consent to service by electronic means, that it has to be consent to service, not simply consent to communications.
Well, the question that arises is, leave aside for the moment the response of Mr. Abdul Malik on August the 9th, but the request talks about preferred communication method for serving summons. So there's plainly a reference to serving something, some form of proceedings, and further communications. Do you accept that if Mr. Abdul Malik had said yes to the totality of the request at D25, that would have been a sufficient consent to service of the claim form? Or does your case really depend entirely upon the fact that he doesn't talk about service in his response at all?
Yes, well, I think actually what we would say is that it's stricter than that, is that if he wanted to serve the claim form electronically, he should have said, do you consent to service of the claim form electronically, rather than putting it somewhat more broadly than that, which he did. But even beyond that, we would say that the response to that email frames it in an even narrower perspective. So the response says, address the related communications, and only for the time being to the following email addresses. And we would say that that's a far cry away.
What do you say all the related communications for the time being means?
Well, one would assume it's communications about the case. It's a solicitor emailing a defendant to a case saying, I'm on record dealing with this. Please confirm that you're happy for me to communicate through these means. And what we would emphasize again is the express provision in the rules, which place the onus on the serving party to clarify the extent to which a party is willing to accept service by an alternative means. And if there is ambiguity, which we say there is at the very least in these communications, what the follow-up question should have been from Mr. Kadir's side is, we have issued a claim form and we're going to serve it on you. Please provide the address for service. And we take support, we say, from that in, it's a UK decision, but it's a Supreme Court decision, which I referred to in my skeleton argument of Barton and Wright Hassel. And if Your Honour wanted to turn that up, it starts at page K89 in the bundle.
Sorry, where is it?
K89. Should be some way towards the bottom, although I presume you're using case lines.
Yeah, I have it.
And the relevant facts there are summarised if you go forward to K92. It's at paragraph 4. And I'm happy for Your Honour to take time to read that. In effect, what happens in that case is solicitors come onto the record and they send an email to the claimant asking that all correspondence be addressed to them in the future. And they also sent an email to the claimant saying, I will await service of the claim form and particulars of claim. And what then happens in turn is that the claimant purports to go on to serve those documents by email. And ultimately, the defendant's position in that case is that they maintain that, notwithstanding that they sent that email, they hadn't consented to service by email. So that's the factual background, which we would say, of course, is not directly comparable, but it does give us an indication of some similar issues arising before the Supreme Court. And I think this was in the context of the claimant serving his claim form out of time, and therefore the issue is whether or not it deprives him of his right to bring a claim at all. And if Your Honour, if you then go forward to paragraph 20, and this is Lord Sumption, but we have the majority's view on that, and this is a comment on the claimant's assumption that given the circumstances he could serve by email. And what Lord Sumption says is that he wouldn't accept that the assumption was in itself reasonable. He says Berryman's, the solicitors, had initially contacted Mr. Barton by email, and they engaged in brief and desultory email correspondence with him between the initial contact and the attempted service of the claim form. In rejecting Mr. Barton's case that he had complied with the practice direction, the district judge held his email correspondence with Berryman's did not amount to an indication that he could serve the claim form upon them in that way. I think that was right. And he goes on to say, but in any event, the point is not before us because of. The point there is that even though we have this broader and what we would say is brief and desultory email correspondence in this case, we would say that that doesn't rise to the level required under Part 9 for the provision of consent to electronic service. And irrespective of the fact that the documents were ultimately received by email is an irrelevance. The question is, was service properly effected under Part 9 or not? And we say that it, first of all, that it was not. And second of all, that there is, at the very least, sufficient doubt about whether a service has or has not been properly effected, that the just order to make, in accordance with the overriding objective, and even putting aside the submissions that we have on the real prospect of defending the claim, is such that the just order to make is to set aside judgment and let this claim run its proper course. And of course, we would say that that has other advantages when it comes to the overriding objective and protecting the interests of judgment generally. I don't think one can ignore the potential negative consequences that come with a court-entered judgment as opposed to a party by its own consent willingly paying off a debt that it owes to an employee, and how that might be perceived in the market generally or in the employment market. And in my submission, we have a situation here in which the defendant not only has a valid defence to the substantive amounts in this dispute, but it's never sought to deny the claimant his contractual dues. It accepted that there were issues calculating those dues. Partly that arises from the unique circumstances in which the claimant was paid, given that part of his payments were paid in the jurisdiction that he was working and part of them were paid in the DIFC. And there are also unique circumstances that arise in calculating what his contractual dues were because of the circumstances surrounding his dismissal. And what had to be worked out was, well, given the circumstances of his dismissal for cause, is he entitled, for example, to his notice? Is he entitled to end of service gratuity, and if so, how long does this entitlement run, and does it include a notice period or not? What are his outstanding salary payments when one refers to what he has been paid in one jurisdiction and what the balance to be paid is in the other? So the point is that these were matters which the defendant has admittedly taken some time to work out, but there were good reasons why that was the case.
Well, Mr. Doherty, how do you justify a period between the 25th of March termination letter and the 23rd of September letter after proceedings have been issued, saying we agree we owe you $207,000? It's a 6-month period during which no payment has been made and apparently no offer has been made. No statement has been given as to post-contractual rights of any kind.
Yes, Your Honour. What one would say is that at no point has the claimant ever been told you're not getting anything. It was always made clear that this was a sum to be calculated. And what we would also say is that it's one thing for an employer to accept that it is going to make a payment to an employee and being late in that payment, with an employer having necessarily acted contrary to the provisions of the DIFC employment law in the way that has been pleaded by the claimant in this case. And that's an important point, because a judgment in this instance isn't only for wages up to X date. In fact, we don't have that in the particulars of claim anyway, so we don't know what a money judgment would actually be being applied to. So that's one of the reasons we say that this approach of entering partial judgment wouldn't be appropriate anyway. But the main point is that for the submissions I've already made to Your Honour, we haven't got a scenario in which the claimant was entitled to enter default judgment anyway, because he hasn't properly served the claim. And if he hasn't properly served the claim, then it's to be set aside regardless of any other consideration. Those points really to add into my further submissions on whether or not there's a good reason why the whole of the judgment should be set aside, which we say that there is.
All right. Anything else you want to say?
Yes, Your Honour, and perhaps it's a matter for consideration in reply, but if you were not with me on the suggestion that service hasn't been affected, one might also wish to consider whether entering judgment is in fact the proper course procedurally in this case, particularly with the issues I've identified in segregation of the basis of payment. And it may be that even if Your Honour was minded to make an order which put the claimant into his money in some way, that probably the more appropriate form of order would be for an interim payment of some kind under Rule 25.8.1.3, rather than entering judgment on the amount. And that would then leave the balance of the issues to be considered in the round, rather than having to be siphoned off as issues. But I should stress that that's very much an alternative submission when we say the judgment has to be set aside in this case.
Yeah, understood. All right. Thank you very much, Mr. Doherty. Mr. Hidir, you will have gathered from what I've already said that it seems to me that there are arguments which arise in relation to the sum of money owing to your client in excess of the $207,000 approximately, which is admitted to be due in the letter of the 23rd of September. If you want to address me about that, now is your chance to do so. You've already made a number of points which I've taken on board. But if you want to address me about that, now is your chance. But I'm more interested in whether or not what you have to say about the irregularity of service.
Okay, thank you, Your Honorable Justice, if you can allow me, I want to refer back to the question of service, to the issue of service. Only if you
Yes.
I will say, and then I will reply to your question. Regarding the service, the person to whom we send the email is the managing director. He is not any person. He is the manager or director of the defendant. And the subject of the email sent to him on 9 August is the case number. Even I explained to him also there is 14 days for your company to reply or to submit their your defense if you have defense. This is regarding the service, and after that the second day he sent me another third email also, and he admitting this all. I believe the service has been done properly according to part 9 of the rules. This is 100% sure. And also, I think in their application, they said they don't aware of the procedure before the DIFC courts. I think this is not true, Your Honorable Justice, because they have a lot of cases against them. They have other lawyers also representing them before the DIFC court. This is regarding the issue of service. I think there is no issue or there is no failure from my client side to serve them or to give some service of the case and attachment. Regarding the amount which they offered after 6 months, Your Justice, he is an employee. They terminated him. Before the termination, 3 months, they didn't give him his salary. After the termination, they terminated him in March 2021. Their letter in which they offering the money in September. This is at least 6 months, Your Honor. This is unfair for an employee. Also, he sent them letter with on 11 April, after few days after his termination, he asking for the reason for his termination. They didn't. They failed to give him any reason. Then, after that, as I previously explained, they call him in Sudan, which is not his jurisdiction, and they make investigation in respect of ex-chairman who withdraw the money. As I told you, I explained previously, this money already written in the record of the company 6 years ago. I don't think it is a reason of termination. The defendant took this only to put it as a reason, but it is not a real reason. The real reason is aggressive termination because they failed to pay him, and their letter dated 23rd September is the proof of their failure. And according to the UAE law, labor law, if 3 months or 2 or less employee has not been paid, he has the right to stop from the work, and he has the right to file a case and claim aggressive termination. I don't think, Your Honorable Justice, they have any reason for the judgment, default judgment, to be set aside, and I think the proper thing, which is fair, their application should be rejected with cost. Regarding the difference between the amount they offer to my client and the amount actually he is claiming, I think my client refused to reply or refused to cooperate with them because they give this offer during this case is pending before the court. So that is why he didn't give, because I think they want to make settlement, final settlement for the amount which they offer to him. He don't want this. He wants his full claim as mentioned in statement of his claim.
Yes.
There is another thing, yes, Your Honorable Justice, if you can allow me. Also regarding his visa. His visa, according to the law, employment law, says that, I think article saying that the employer and employee should cooperate each other after the termination of the employee to cancel his visa. Till now, up to date, my client, his visa is not cancelled. He is in the system. His visa is already expired. He cannot come. And I think they make this intentionally. This is also contravention of the employment law. And we put all these things in my skeleton of my arguments. I beg your Honorable Justice to go through my skeleton arguments and to the document also. We insist that this application should be rejected and the default judgment should be executed again and again.
Yes. Thank you. Mr. Doherty, what troubles me most is the fact, as I've already made clear, that your clients accept that $207,349 is owing by way of post-termination wages, benefits, and so on and so forth. As appears from the correspondence that I've seen, the letter of termination said that administrative and financial matters would be sorted out in a further letter to follow within 7 days. That's at D23. Within the next week, a representative from the Finance Department will contact you to finalize the administrative and financial procedures. There's no evidence that was done. There's certainly no payment ever been made. And your clients were well aware of the bank account to which payment could be made because they've been paying the claimant in any event. Now, even supposing that I'm with you on the questions of good arguable case, good prospects of success in relation to the balance over and above the $207,349, and even supposing I'm with you on the question of irregularity of service, it appears to me that that sum of money simply ought to be paid. There are a number of ways in which I can achieve that, one of which would be to set aside judgment conditionally upon payment of that sum within, let's say, 7 days, either to Mr. Hidia, his firm's bank account, or directly to the defendant, to the claimant, I should say. The other thing I could do, I suppose, is to make a condition that there be payments into court in case there are other issues that arise in relation to costs. What do you say about either of those options?
Yes, Your Honour, I don't know whether you would allow me 5 minutes to go take instructions from my solicitors on that.
Well, that might be the sensible thing, because to be absolutely plain with you, Mr. Doherty, it seems to me that money ought to change hands straight away. I see no basis for your clients holding on to the $207,349 that they admit is due. And, you know, a check, an electronic bank transfer should take place, in my view, immediately. One of the things I could do is simply adjourn this application for that payment to be made, and then deal with the rest of it on paper, on the basis that there are arguments which will have to be sorted out by the court as to who's right or wrong about justification for cause and all the points that Mr. Hidia has made. In one sense, that's the technically most correct way of doing it, I think, because it gives your clients the opportunity to make the payment without determining anything on this application, which I would then do once the payment had been made and deal with it on paper. Do you want to take 5 minutes now to take some instructions?
Yes, Your Honour, I think that would be sensible and extremely helpful from my perspective.
All right. I'll remain online, so to speak. If you want to just turn your camera off and mute yourself and take instructions, and Mr. Hidia can stay online as well for the moment, and we'll await your return in a few minutes' time. Mr. Hidia, can I just ask you this? If money is to be paid straight away, which is what I think should happen, is it best to pay it into your firm's bank account, or best to pay it to the claimant's bank account that the defendants know of already from payment of his previous salary?
Okay, Your Honorable Justice, it makes no difference. He is my client. I don't know whether still they are keeping his account number with them or no. But if they want to submit this amount as your order, I can give my account also. No problem.
Well, I think that would be the easiest thing. Then there's no argument about it. Are you able actually to give your bank account details by email straight away to Mr. Doherty's lawyers, to Holman Fenwick?
Yes, I can.
Why don't you do that straight away whilst we have this 5-minute break and Mr. Doherty takes some instructions? Then there can be no reason why payment can't be made electronically as soon as may be, directly to your firm's bank account. All right, let's take 5 minutes now. If you need a bit longer, we'll take as long as you need, Mr. Doherty, within reason. But I'd expect you to be back within 10 minutes or so.
Yes, I'll just put my camera back on. Thank you.
Very good. Thank you very much. Thank you.
Sorry, I realised I was speaking now on mute, Your Honour. I've taken instructions, and thank you for the opportunity to do that. Can I just check, first of all, you're able to hear me?
Yes, thank you.
Thank you. I think we see sense in the approach you've suggested. On taking instructions, my client's preference would be adopting one of the solutions you suggested, which was payment of monies into court. And there are a couple of reasons for that. First of all, there are obviously in due course going to be some arguments surrounding the costs of this hearing. And secondly, and perhaps more importantly, my learned friend has already made it clear that the claimant doesn't accept that the $207,000 constitutes the entirety of his entitlement and is going to be pursuing the rest. For reasons you've already seen, no doubt, in my skeleton, we consider that claim for the balance to be a very weak claim. And payment of monies into court may well be a solution that helps achieve justice between the parties as this dispute progresses.
Yes. So what is the form of the order that you are, in the light of my indications, asking the court to make?
Yes, Your Honour, I think what we would suggest is payment of that money into court. I will ask my solicitors to message me if there's anything wrong with the suggestion that we can have that money paid into court in 7 days. And that judgment be set aside entirely, with the entirety of the claim then to be considered. So whether the order specifies any of the reasons why it's set aside, whether it's because there are prospects or a good reason or because of service, I don't think necessarily matters, so long as the judgment is clear that it's setting aside or the order is setting aside the judgment in its entirety.
Well, I think I would want to say, in addition to that, on admission by the defendant that the sum of $207,349 is due and owing, and on payment into court within 7 days, judgment be set aside. I don't want there to be any comeback on the fact that you're accepting, as I think you have in very clear terms today, that that sum of money is due.
Yes, I think that sounds like it could be reasonable. Yes, and it may well be that it can be recorded in a recital as well.
Exactly. It'd be the form of the order would be on admissions made by the defendant that the sum of $700 and I've lost track of it again.
207,000.
207,349.
Yes.
Is due and owing from the defendant to the claimant, and on payment of that sum into court within 7 days, judgment be set aside. And then that leaves us to argue about the costs of today. I'll either give you an extempore judgment in a moment, or I'll put it in writing as to why I take the view that I do. But I'm clear that that is the view that I hold.
Yes.
And then the only question would be costs. It probably makes sense, does it, for me to give an extempore judgment, and then we can argue about costs in the here and now?
Yes, I don't think I have any particular objection to that approach.
Right. Well, as is always the way with an extempore judgment, I may have to fiddle around with it afterwards to make sure it's entirely grammatical and makes sense, but it will give you the reasons for what I'm doing, so we can then try and deal with cost today and have this whole matter sorted out.
Yes.
All right. So here are my reasons for the order I'm going to make. During the course of this hearing, even if it was not entirely clear beforehand, the defendant has accepted that it is liable to the claimant in respect of salary and benefits in the sum of US dollars 207,349 pounds. After discussion with the defendant's counsel, the defendant agreed that that sum could be paid into court within 7 days, and that an order could be made on the basis of admissions that that sum was due. On that basis, I intend to make an order that judgment should be set aside on the recording in the recital of the order that the defendant has made that admission, and on condition that there is payment into court of that sum within 7 days. Judgment should then be set aside for more than one reason, but primarily because the defendant has real prospects of defending the claim on the basis that the claimant's employment was terminated for cause on account of admitted irregularities in accounting procedure for which he was responsible and which resulted in the sum of approximately US dollars 1.5 million being unaccounted for, apparently being received by the chief executive. The effect of the arguability and the real prospects of success of that defense is to negate large elements of the claim for 447,700. It was on the 23rd of September 2021, some 6 months after the letter of termination, that the defendant first accepted that the sum of 207,349 was due and owing. It is right to note that in the letter of termination of the 25th of March 2021, which expressly terminated the claimant's employment for cause, effective immediately, the defendant stated that, quote, within the next week, a representative from the finance department will contact you to finalize the administrative and financial procedures, unquote. There is no evidence of any such contact, and it is accepted that no payment was made of the sum which is now admitted to be due, and which could, in my view, have been calculated in that 7-day period and paid within it in accordance with the provisions of the contract, which required payment within 7 days of termination. The letter of the 23rd of September was sent some 22 days after a default judgment was entered for the larger sum which is still claimed by the claimant. I will set out briefly the history of the matter and given the clear view that I formed that the defendant has a realistic prospect of defending the balance of the claim, it is best that I should not enter into any detailed discussion of the merits of the parties' respective positions, as it is inappropriate for the court to embark on a detailed investigation of disputed facts which are in issue between the parties. What the evidence shows, however, is this. On the 1st of August 2019, the parties entered into an employment contract whereby the claimant was engaged as managing director of the defendant's subsidiary in Mauritania. Clause 2 set out a basic salary of US dollars 12,000 per month and various allowances of one kind or another, amounting to a not insignificant additional figure. The contract provided for termination on 6 months' notice or termination for cause in accordance with the DIFC employment law, where the employee committed a fault resulting in substantial material loss to the company, with a proviso as set out in clause 12.1 little c. It was specifically provided at clause 12.3 that on termination of employment, the defendant should pay all wages owing to the employee within 7 days after the end of the pay period. And clause 12.4 provided for vacation pay and the like. I should say that the governing law of the contract was the law of the DIFC. The defendant's position is that the claimant's employment was terminated because investigations by a parent company revealed financial irregularities and misappropriation of funds of approximately US dollars 1.5 million at a time when the claimant was the financial manager of the defendant's subsidiary company. The investigations were such that the claimant himself was involved and spoke to those investigating, as recorded in the findings of the committee. The committee produced a report on the 24th of March, which the claimant signed. I need not go into the details of what was said in that report, but essentially the claimant acknowledged that he delivered approximately $1.5 million in cash in 2015 or other years after being asked to do so by the then current Chief Executive Officer. The claimant acknowledged that he had not signed delivery or receipt documents when withdrawing the cash or delivering the cash and had not obtained approvals from the officials in charge when doing so. That it was accepted was not in line with company procedures, and the claimant expressly acknowledged that there had been an administrative or procedural error or mistake in that matter due to the lack of obtaining the signature of those whose authorization was required and by way of receipt. It is said that the claimant is now subject to an ongoing criminal investigation in Sudan, where the subsidiary operated. The claimant says that he has received no summons of any kind and is not aware of any such proceedings. Those are matters for the future and not for now, being in dispute between the parties. I had considered whether it would be open to me to set aside judgment only in respect of the part of the claim which is disputed, but to leave intact a judgment for the lesser sum of $207,349, which is the sum accepted to be due, but the way in which the parties have approached the matter allows me to make an order in the form that I now do. It is clear to me that the defendants do have a realistic prospect of success in their claim that the claimant's employment was terminated for cause, and in showing that only the lesser sum which is admitted is due, for all the reasons which appear in the witness statements filed and the skeleton argument served on behalf of the defendant. The defendant advances other grounds why the whole of the default judgment should be set aside in any event, which is why the course that has been adopted makes sense. It is contended that the claim form was not properly served on the defendant, or alternatively that there is sufficient doubt about the validity of such service that judgment should be set aside in its entirety, ex debito justitii, or as a matter of the court's discretion, in accordance with the provisions of RDC 14.1, by reference to RDC Articles 13.4 and 40.2 brackets 2, close brackets. What the documents in evidence show, once again, is that on the 25th of March, the defendant terminated the employment of the claimant for cause in the manner I have already outlined. On the 9th of August, the claimant's lawyers emailed Mr. Abdul Malik, a director of the defendant in the DIFC, stating that they were acting for the claimant in the above-mentioned claim, which was not defined, but must, I assume, for present purposes, be taken to refer to previous correspondence, in which the claim for wages and other benefits was advanced. The email sent by the claimant's lawyers went on to say this in the second paragraph, quote, kindly confirm in writing the preferred communication method for serving summons and further communication with the company, open brackets, email or courier or other, close brackets. The response from Mr. Abdul Malik on the same day was this, open quote, thank you for your email. Please address all the related communications for the time being to the below email addresses, unquote, and then 2 email addresses were given. Later that same day, the claimant's lawyers sent a further email with attachments, including a claim form. In that email, in that email, the following appeared, open quote, kindly be advised that the attached claim, CFI 056-2021, with its supporting documents, has been filed against Exepresso Telecom Limited before the DIFC Court of First Instance on the 26th of May 2021. Following the written confirmation via your email dated 9 August 2021 regarding communication method, please consider this email with its attachments as summons served to Exepresso Telecom Group Limited as defendant. Subject to the DIFC Court's rules, you may file an acknowledgement of this summons within 14 days, and you must file and serve your defence within 14 days. The unquote, the claim and supporting documents were attached, including the claim form, employment contract, a financial claim, and the termination letter. I should point out that in the email, the name of the defendant was wrongly spelt with an additional E in the word Exepresso. That defect also appeared in the claim form itself, which was extremely limited in the details of the claim provided. all that the claim form actually said by way of details under the heading particulars of claim was this, open quote, end of service gratuity, unpaid salaries, notice period, aggressive termination, annual leave, dash, travelling tickets. The amount claimed was US dollars 447,700. The defendant was, at the time of the exchange of emails to which I have just referred, not represented by lawyers, and on the 26th of August, that is within the 14 days allowed for acknowledgement of service, asked the DIFC court for an additional 14 days in order to attain the services of a DIFC lawyer. The court informed the defendant that it had either to file an application for the court file an application with the court for an extension of time or to seek the consent of the claimant to such an extension. The court was informed that the defendant was intending to file a defence and counterclaim. On the 29th of August, the defendant asked the claimant's lawyer for a 14-day extension of time, but on the following day, the claimant's lawyers refused such an extension and sought judgment in default of acknowledgement of service, which was granted by the court on 1st September. On the 5th of September 2021, that default judgment was sent by email to the defendant, and the defendant then sought assistance from DIFC registered lawyers, which resulted in the current application to set aside the judgment, which was made on the 16th of September 2021. It is in those circumstances that the court must consider the terms of the rules and whether or not service was properly and validly made, and whether the judgment therefore was regularly entered or not. Rule 9.3 RDC provides for an exception to the ordinary rule that service on a company must be made by serving proceedings on the registered office. (9.2) open brackets 4 close brackets RDC provides that electronic communication can be used for service, but only in the circumstances which are set out in RDC 9.3. There it is said that a document which is to be served by electronic means can only be served where the party who is to be served or his legal representative have previously expressly indicated in writing to the party serving that they are willing to accept service by electronic means and given a fax, email address or electronic identification to which it can be sent. Rule 9.3 brackets 3 close brackets provides that the party seeking to serve the document should first seek to clarify with the party who is to be served whether there are any limitations to the recipient's agreement to accept service by such means, including the format in which documents to be sent and the size of the attachments that can be received. The question therefore arises as to whether the defendant did expressly indicate that it would accept service of the claim form by electronic means in its email of 9th August 2021. I conclude that it did not unequivocally do so because it merely said open quote, please address all the related communications for the time being, close quote, to the addresses in question. There was therefore no express consent to service of a claim form, although it is fair to point out that the plaintiff's lawyer's prior message referred to, open quote, serving summons, close quote, full stop. In circumstances where no lawyer had then been instructed, the request to address, quote, all related communications to Mr. Abdul Malik's email address as given by the defendant could not reasonably, in my judgment, be understood to be a consent to service of proceedings by that method. There was no express consent to serving a summons by that method, let alone a claim form, if the difference was plain to anybody's mind at the time. In the result, I take the view that the claimant was bound to serve the proceedings in the conventional way by serving them on the registered office of the defendant in the DIFC. In those circumstances, the judgment should be set aside in debito justitiae. If I was wrong in that conclusion, as a matter of discretion, it seems to me there is plainly enough doubt about the validity of service for the court in its discretion to set aside judgment in accordance with the principles set out in the decision in Grand Valley General Trading LLC against CGICO Suntech Limited, 2018 DIFC CFI 044 on 27th December 2018 at paragraphs 25 to 28. The reason is that the court cannot be satisfied that the conditions required for entry of a default judgment as set out in RDC 13.46 have been fully met. In those circumstances, judgment would be set aside under RDC 14.2 brackets 2. The defendant further relies on the fact that its name was spelt wrongly at the time of the entry of the default judgment in the claim form and in the judgment itself. It submits, therefore, that the proceedings and the judgment did not validly implead the defendant, and the court should take a strict approach in determining whether the conditions for service have been met, since the effect would be to deprive a defendant of the opportunity to defend a claim. I need not decide that point, but if it had been the only point raised by the defendant, I doubt whether it would carry any weight, because amendment of what was either a typographical or spelling error would accord with general principles of justice, whether such amendment failed to be made before or after judgment. The reality here is, however, that given the history as I've recorded it, there is a measure of opportunism on the part of the claimant in seeking default judgment in the circumstances set out, when the defendant had sought an extension of time and was unrepresented with a known defence to at least part of the claim. In those circumstances, it would be unjust to deprive the defendant of the opportunity to run its defences in respect of that part. It is extremely odd, to my mind, notwithstanding what is said on the plaintiff's behalf, on the claimant's behalf, that there was no response to the letter of the 23rd of September, where an admission was made as to the sum due. The reason given on his behalf was that he did not accept that was the only sum due. But the absence of response is odd, just as the failure on the part of the defendant to pay the sum, which is admitted to be due, is likewise unjustified. The defendant applied promptly to set aside the judgment once, the defendant applied promptly to set aside the judgment once lawyers were instructed, following the service of the default judgment, and justice demands that the defendant be given the opportunity to defend where there are disputed matters of the kind alleged. Given the fact that the setting aside of judgment is made on the basis of admissions of a sum due and payment into court of that sum, the order therefore takes full account of the position between the parties as I have identified it. On that basis, the whole of the judgment is to be set aside, provided that the payment into court is made within the 7-day period which I have ordered. There remains then, I think, the question of costs, and I will listen to the parties' submissions on that subject. The only other element, I suppose, is this, and I would also invite submissions on it as to what orders, directions should be made for the future progress of the claim. It appears to me that the claimant will need to serve proper particulars of claim of the basis on which it alleges the additional sums due, and then there needs to be provision for service of defence and the like. Shall I start with you, Mr. Doherty? It was your application, so you can make whatever submissions you wish in relation to both those matters.
Yes, Your Honour, thank you. Unsurprisingly, we're seeking our costs of the application. Can I check whether a copy of the cost schedule has made its way to Your Honour or not? Because if not, I'll arrange to have that sent to your email.
I haven't seen it. When was it filed with the court?
I think it was yesterday.
It has to be 24 hours in advance, doesn't it?
Yes, I understand that. My understanding is that it was. I will double check with my instructing solicitors.
All right. Is there some way you could put it up on the screen or something? I'm not quite sure. And perhaps you have to send it by email. I'm not sure. Anyway, let's deal with the principle.
It was 24 hours, but I'll deal with the principle in the first place. Yes, Your Honour. Well, we would be asking for a cost really for a number of reasons. We say that the claimant's conduct, not only in resisting this application, but also in having made it in the first place, is conduct which clearly justifies the usual form of order. The applicant has succeeded in the application and costs should follow the event. But on top of that, what we would say is that based on Your Honour's judgment, the request for judgment in the first place was not one which was properly made. And as Your Honour has pointed out, pointed towards a degree of opportunism on the part of the claimant in circumstances where it was fully aware that this was going to be a defended claim, that the defendant was then a litigant in person and was seeking an extension of time in order to properly defend the claim. What we would say beyond that is that there's further unreasonable conduct in the claimant's refusal at that point in time to consent to what was a reasonable and modest request for an extension of time, first of all to instruct solicitors, but secondly to file an acknowledgement of service in response to the claim form. We say that smacks of a cynical attempt to try and achieve a tactical advantage, and in our view, given the relative strength of the defence as opposed to the strength of the claim, in order to achieve a substantial windfall beyond the claimant's entitlements. We also say that has to be viewed in the context of there being further failures still to duck out of the application at a point in time when it would have been entirely reasonable to do so. And another example of that is following the 23rd of September letter, where in effect money is put on the table, and the course that the claimant decided to adopt was simply not to respond to that letter, when it would have been perfectly reasonable to expect, first of all, some form of response to be sent, but second of all, for there to have been acceptance that there was clearly a reasonable dispute as to the balance which would need to go to trial, and therefore that judgment ought to have been set aside. So those are the opportunities to have avoided the need for this application in the first place, and certainly to have avoided the need for this hearing. Your Honour, there's also a question of conduct when it comes to the approach to this hearing as well. And Your Honour is, of course, familiar with this, but what we have had is, in my submission, an unreasonable approach to the filing of evidence in this case, which has led to numerous rounds of evidence that were, to put it in simple terms, not required. There were 2 occasions on which the claimant filed witness statements and further evidence without seeking permission from the court, and certainly without receiving permission from the court. In the interests of trying to be open and cooperative, one of those was retrospectively consented to on the basis that the defendant would be able to provide a responsive witness statement. But the second and further attempt to provide what was a third witness statement was refused by the court. And even in circumstances where the application to rely on that further evidence was refused, that information was still referred to in the claimant's skeleton argument, which we say is unreasonable conduct of proceedings generally, but of course that carries with it substantial cost consequences, because it's not simply filing an application in a witness statement and giving a respondent the opportunity to reply to it. There are further witness statements which generate the production of further responsive evidence, and there is inevitably going to be a degree of time liaising with the court when it came to the third witness statement in particular. And so we say that above and beyond that, this has been more costly than it needed to be, and that arises entirely as a consequence of the claimant's conduct in preparing for this application. And so, Your Honour, in my submission, not only do costs follow the event in principle, but the conduct by the claimant of this application has generated significant further costs, and that the costs set out in the schedule, which I hope I can provide to you, should be awarded in full. And I can tell you that the dirham sum is 166,266. I should say, as my learned solicitors have helpfully pointed out, we did actually write to the claimant about this, and it is in the hearing bundle at M1. And of course, Your Honour, I've referred you to various other points in time at which it would have been reasonable for the claimant to resile from its position in making and sustaining its request for default judgment. But this is a further letter which was, for the avoidance of doubt, to put the claimant on notice of the cost consequences of not consenting to the application. And you'll have the response to that at M3, which was effectively 2 substantive lines, which says that our client refused your proposal for the reason that you were properly served but failed to submit their defence in time, and up to date you didn't submit any material or valid evidence to give grounds for default judgment to be set aside. And we say that that's persistence in the opportunism that has led us to this hearing in the first place.
Yes. Mr. Hidia, what would you like to say?
Okay, Your Honorable Justice, actually regarding the cost, I will talk about the last point Mr. Stephen is talking about. Regarding the cost, the basic reason that this cost has been happening or has been occurred, the reason that the defendant failed to pay the claimant his right within 7 days after termination. If the defendant paid the claimant his right within 7 days, he couldn't come to the court. The reason he came to the court is their failure not to pay him according to the contract and according to the letter of termination. That is why claimant has, there is no reason to make the claimant bear all these costs, and he has to get his rights within 7 days. Instead of that, they give him letter after 6 months, 23rd of September. Instead of 7 days, 6 months. This is not just and not fair. That is why my client refused, or he will not accept, or he will request the Honorable Justice to reject these fees or this cost. So.
Yes.
If you can allow me, Your Honorable Justice, regarding also, yes. I would like to talk about the visa of my client. Till now, he's not able to come to the country or to the United States because defendant refusing to cancel his visa. According to the employment law, it should be cancelled 1 month after his termination. Till now, he's not able to, they are refusing to terminate his visa and to allow him to come here to Dubai. He's outside right now. So my request
where is he?
He's outside of UAE, sometime in Egypt, sometime.
Yes, where?
I think sometime in Egypt, sometime in Mauritania, in Sudan. He's traveling, but he's not able to come because his visa in the system is still visa in the system, but not cancelled. If he come, they will ask him your visa in the system, and you have to either to be cancelled or to be renewed. So according to the termination, they have defendant should to cancel his visa to allow him to get a new visa or to come on visit visa like this. So I request your Honorable Justice to add this to be an order.
Where's the provision in the contract relating to the visa? Is there an express provision in the contract about visas?
Article 50 is employment termination.
Mr. Doherty, do you know anything about this visa problem?
I think it is 57, Your Honorable Justice. 57 on the employment law applicable.
Oh, it's in. I see. It's not in the contract. It's in the employment law.
Yeah.
Do you know anything about this, Mr. Doherty?
I'm sorry to say, Your Honour, it's not an issue I'm particularly across. I mean, I don't know whether this is something which, if it is an issue, or certainly an issue that can be or is to be dealt with by this court, it would presumably be something that would come in due course in a particulars of claim. If there's an enforceable right or some form of specific performance. I'm not entirely clear on what it is that's being asked for, but I'm not sure that it's something that can necessarily be disposed of today.
Well, I don't think I can dispose of it today unless I have evidence on the subject and so on. So it'll probably have to wait. Let me deal with the question of costs first, anyway. this is, in some respects, an unusual case, because although I have found that the defendant was entitled to have the judgment set aside ex debito justitiae because of an irregularity in service, there was some doubt about that because of the exchanges of correspondence between the parties, and it might be understandable that the claimant considered that some consent had been given, although in my view that would not have been an entirely reasonable course to have adopted. There are faults, it appears to me, on both sides here. The claim form in itself is wholly inadequate in terms of particularization of the makeup of the claim. It is odd, as I've said, that on the 23rd of September, when an admission was made as to sums due, there was no response to that, not even to ask for that money to be paid. It is true also that the claimant has sought on a number of occasions to adduce additional evidence or make additional comments above and beyond the procedure which is allowed for by the rules, and directions have had to be given in respect of that. Finally, in that context, on the 14th of November, there was an invitation by the defendants to consent to the setting aside of judgment on the basis of the defences advanced, which was refused. Set against all of that, however, is the point that the defendant did not make any payment to the claimant within 7 days, as the contract required, did not produce the letter which it is said was going to be produced by its finance department to deal with such matters, did not make a payment on the 23rd of September when a sum was admitted to be due, and has made no payment since until compelled today to do so in the face of the court's pressure. It is also true to say that there was a failure to file an acknowledgement of service at a time when what was being sought was an extension of time, and no point being taken as to irregularity of service. Albeit at that time, of course, the defendant was unrepresented. In those circumstances, I've come to the conclusion that it would not be right for the defendant to be awarded all its costs, though it has succeeded on its application. In my judgment, the appropriate order to make as a matter of principle is that the defendant should be entitled to 50% of its costs, and as to quantum, we can look at that in a minute on the basis of a summary assessment in order to dispose of the matter.
Yes, Your Honour, thank you. I understand an email should hopefully have been sent marked as urgent, I assume to the registry.
Yes, sorry, Shane Gibbons here from HFW. We understand that a copy of the statement of costs has now been put before you, Justice.
Have you sent a copy to my DIFC email address?
No, we've sent it. We've resent it to the registry. Just confirmed that they have put it before you. It's from Shayla Al-Gharib.
Sir Jeremy Cooke, I just emailed you the statement of costs. Your DIFC
yes. Which email address did you send it to, please?
DIFC court's email.
Okay, let me just find that. Bear with me a moment. Right, I've got that. Sorry. Yeah. Yes. Mr. Khidir, have you had a chance to look at this?
Yes, sir. Yes, Your Honorable Justice. Yes, I have seen it this morning only. Before the hearing, maybe 1 hour before the hearing, I have seen it. But actually, I do object. I raise my objection against this in full in total, because the reason that we come to court is the defendant. They make my client come to the court. This is not the way that they can claim any cost or anything, because they are the reason that my client come to the court.
I understand that, Mr. Khidir, but the view I've taken is that your client should pay 50% of whatever are reasonable costs. And what's being claimed here is 166,000 approximately, which is about the equivalent of something like £46,000, is it, Mr. Doherty, something of that kind? What I really want, Mr. Khidir, is your comments on the reasonableness or otherwise of this bill. So do you have objections to the size of the bill as opposed to the question whether you should pay it?
Yes, Your Honorable Justice, can you give me the question again?
Yes, I'm looking for any submissions you want to make about the size of the bill, the quantum, the amount that's claimed, as to whether the amount is reasonable.
I think I believe that the amount is not reasonable, because even the course of time that they raise this application, I don't think it will. This calculation is fair or and it is not just. I don't think it is reasonable. It is far away from.
Well, is there anything in particular, looking at this bill, that you would want to draw my attention to as being particularly unreasonable? I'm looking at the bigger figures, for example, here. If you look at work done on documents, there is 17 hours, 17 and a half hours nearly spent up by one person and 11 hours spent by somebody else, which is the equivalent of some 47,000 dirhams. Those are the big figures that tend to stand out, I think.
Yes,
and perhaps the 18,000 odd for simply other work not covered above, where no details are given. Well, Mr. Doherty, can you help on what the other work is not covered above?
Yes, Your Honour. So my understanding is that the time recording practices adopted by my instructing solicitors are work on documents is strictly work on documents. Yes. Some solicitors might bill ancillary items around that, but my instructing solicitors don't. So that would be as I understand it, things like research, internal correspondence, case analysis, and work of that sort. Whereas when it comes to work done on documents, that would, be strict sitting down, drafting a witness statement. It would be that time. And I don't know if it assists, Your Honour, but of course one might look at the work done on documents section and think that seems higher than others. If that was for the production of one witness statement in support of the application, I'd be inclined to agree with you. Unfortunately, the state of play in this case is that as a consequence of the responsive evidence, we've had the production of 2 further witness statements. So that's 3 witness statements in total from our side, as well, of course, as of reviewing the additional statements that were put in by the claimant without permission. So the fact that this application has generated a lot more evidence than is normal, we say is actually a consequence of the claimant's own conduct, and that whenever it has come to filing additional evidence, that has been, from the defendant's side, made with permission of the court, and because of the claimant's conduct of these proceedings. So we say that in those circumstances, that sum isn't unreasonable. And in fact, when one steps back, the overall sum being claimed is, in my submission, the norm for this sort of application involving this sort of money. It's certainly not an amount that is unheard of in a matter before the DIFC courts, where, in my submission, the court is assisted by properly instructed solicitors and properly instructed counsel.
Yes. Right, very good. All right. Well, looking at the bill as a whole, and looking specifically at the time spent on the major items, which include other work not covered above, which is undefined, which is distinctly unhelpful for a judge when looking at a bill, it appears to me that some deduction falls to be made from the 50% figure that I've already considered appropriate. 50% would be some 83,000 dirhams. And in those circumstances, making the usual allowances for what is recoverable, I come to the conclusion that the right figure to order is 50,000 dirhams. So I make an award in relation to this of 50,000 as a summary assessment. All right. Mr. Doherty, can you draw up an order for the court's approval, please?
Yes, Your Honour. I note that I forgot to address you on whether there need to be any consequential directions, given a position where...
We need to deal with that now, but it appears to me that the proper particulars of claim need to be adduced within whatever period is appropriate. The real question is, there doesn't seem much point in requiring further service of the claim form because you've got it. So I'm inclined to dispense with service of the claim form, but to require proper particulars of claim to be served within whatever an appropriate period is. Does that make sense?
I think so. I have to say, minded before the hearing started to suggest that from the defendant's perspective, one might need to see a version of the particulars of claim in order to know whether it has prospects and therefore whether one would consent to amendment. But I think the position, or the correct position, is that where service of the claim form hasn't been effected, amendments to the particulars of claim can be made at any time until the claim form is served. So if one assumes that the date of... if one assumes that the date of service is today's hearing or some day after today's hearing, then I think one would expect 14 days thereafter for particulars claim.
The simplest thing to do, to work on the basis, as I've already ordered, that there has been no valid service of the claim form, to simply say that the claimant should serve an amended claim form with full particulars of the claim within whatever period you want to do that, Mr. Hidir. And then we can see, then there'll be the ordinary time period will apply for an acknowledgement of service and defence following that. How long would you need, Mr. Hidir, to put a claim form in which gives all the details of what you're claiming and why you're claiming it, on the basis that 207,000 is being paid to you and therefore you want to claim something more?
Yes, Your Honourable Justice, I think my comment to this statement first, I think the number of hours is very high. It's not an employment case, and I don't think it will need this much of time. This is number one. Number two, the rates that they are putting for the professional fees for the rate, I think it is exaggerated, yeah, too much. I don't think this is suitable with this case. So I raise my objection again. This statement of cost should not be admitted.
Right. Well, I say I've ruled on that already. What I'm asking you now about, Mr. Hidir, is
yes,
the future progress of this action, working on the basis that you're going to receive, there'll be a payment to the court of the 207,000. What's needed now is for you to produce a claim form and particulars of claim which set out exactly the sums you claim and how that breaks down between the different elements of wages and benefits for this and travel allowances and so on and so forth. How long do you need to do that?
Okay, Your Honourable Justice, because my client is outside the UAE, he is traveling due to the reason I mentioned first, that his visa is already expired and not cancelled by the defendant. I think 2 weeks I can make this.
Yes, very good. 14 days.
13 days.
14 days. All right. So the order will say that the claimant is to produce an amended claim form with full particulars of the claim within 14 days. And then the usual provisions will apply in relation to acknowledgement of service and service of defence. And of course, that claim form can be served on the defendant's solicitors, who are now on the record, so there's no difficulty about service at all. And that's as far as we need to take it, isn't it, really?
Yeah, sure. Only one further point to flag up, which is in relation to the order you've just made on costs and potential interplay with the monies to be paid into court, and whether it might be sensible to have some mechanism whereby if your order for costs isn't paid, that it can be offset against the sums to be paid in.
I'm going to deliberately leave that, Mr. Doherty, because this is a case which plainly ought to settle one way or another. And having money in court and a costs order outstanding ought to lead the parties to think in terms of negotiating something. And if at the end of the day there's no settlement, then the court will have to decide on the disputed issues that arise on the amended claim form, and all questions of costs and so on will then have to be resolved, and any offsetting and payment out of the sum in court will have to be dealt with. But as it stands, I'm in favour of leaving things slightly fluid in order to encourage the parties to do the sensible thing. I know encouraging parties to do the sensible thing doesn't always result in parties doing the sensible thing, and clients don't always take their lawyer's advice either. But I'm doing my best to encourage them to do that.
Yes, Your Honour, thank you.
All right. Can you draw up the order, Mr. Doherty, agree it with Mr. Hidir, and then send it to the court for the court's approval?
Yes, Your Honourable.
I'm sorry, Mr. Healy, I didn't hear that.
Yeah, can you? I didn't hear you, Your Justice. Can you repeat? What is the question?
There was the question I asked Mr. Doherty was for him to draw up the order and for you to agree the form of the order with him, send it to the court for approval or for my approval, and then the order will be issued. So on the basis of what I've said in my judgment, you should be able to agree that. And I'm leaving things, as I say, rather fluid in terms of payment into court, which has to be made on the one hand, and the order for costs made against your client on the other, in the hope that it may encourage the parties to negotiate and come to some sensible conclusion about whatever remains an issue. All right.
Okay.
Anything else?
Okay.
No, thank you very much, Your Honour.
Very good. Thank you very much. If you wouldn't mind signing out, then I'll have a quick word with the court associate. So if all the parties would leave and just leave the court as it is, that would be very helpful. Thank you very much indeed to both of you.